Hello and welcome to Easy Chapters. So, the topic of discussion for today is state surveillance. So, state surveillance, in simple, it means the state has the authority to intercept, inquire any matter breaching its national interest of that state, friendly relation with the neighboring countries, if the security of the state is endangered. So whether this power of interception by state is beyond Article 21, that is right to privacy. Article 21 is a fundamental right that has reasonable restriction imposed on it. So there is a scope for state to violate the Article 21. Recently, this matter of state surveillance arose because of the use of the recent development about the Pegasus Spyware that has been purchased by Indian government from, as the story says, that from one Israeli farm, to use it as a weapon for intercepting the public. And as we know that the power of state, the authority of the state can be used if there is a law related to that. So the problem with the Pegasus, the Pegasus spyware incident happened. So what happened? At that time, the main question arises here is because of the uses of this Pegasus by the investigating agencies. Okay, before going that, there is a law to regulate the interceptions too, to allow the interceptions too. Okay, that is called Telegraph Act of 1885. Section 413B of the Telegraph Act says state can use surveillance in the matter related to the public safety and the public emergency. So this public safety and this public emergency, as the Act defines, can arise from if the sovereignty of the state is endangered. Sovereignty. Secondly, if there is a matter of national security, to investigate an offense committed, you can use interception. Offenses. Then, as a fourth term, if there is a friendly relation, and because of any kind of unwanted activities, there is a strain in the friendly relationship with the other country in the international sphere, then to safeguard international relation. So these are the four grounds on the basis of which an incident may arise related to the public safety or the public emergency. Then states under Article 413B of 1885 Telegraph Act, state is permitted to do the interception. But the main issue here arises that whatever the intelligence agencies we are having, just like RAW, Intelligence Bureau, few of the intelligence agencies are not under any kind of law. So hence these companies are not answerable to parliament or judiciary. You can go to any kind of act related to, just to say, Telegraph Act, Information Technology Act, and Criminal Proceeding Code of India. All these acts have given ample relaxation to the intelligence agency. for the state surveillance. So there is a mismatch or absence of law found in India. And this list of the intelligence agency established without any kind of proper law is not limited with the surveillance state defense mechanism. It also relates to the financial mechanism too, just like the CBDT, Central Board for Direct Taxes. So due to this, what is most of the time been witnessed that there is unchecked surveillance, then this data, all the data, whatever been collected by these intelligence agencies are often been misused for the political gains. So that's the biggest issue that India is facing right now, because we don't have any kind of data protection act, data protection. We are having the right to be right for privacy under the Article 21, right to privacy. So in this relation, is it justified? Is it justified to make state surveillance as the weapon for some kind of pecuniary gains, just like political gains, or any kind of economic or social benefits? And India is a subject to targeted surveillance too. That is because of the intelligence grids available. Multiple platforms are there, multiple platforms for this kind of surveillance. So that is the reason that why Indian citizens are now very much prone to the surveillance kind of thing. Though government said that state surveillance is justified under the Telegraph Act, but they said there are 9 agencies that has been established by law, and out of these 4 agencies are continuously doing different kind of surveillances. So it is legal. But this kind of remarks, though they are not accepting that Pegasus has been brought from Israel, that is another matter that has to be investigated well, that is another matter. But we are right now discussing about the matter of the state surveillance. So what government has said? Government said that yes, it is justified. State surveillance is justified. But here we shouldn't forget about the K.S. Puttaswamy case. In the K.S. Puttaswamy case, Supreme Court has upheld that right to privacy is a fundamental right enshrined under the Article 21. Yes, state has the permission to intercept or use any kind of surveillance tool, whether it be in digital mode or it may be in a non-digital mode. So there has to be few conditions to be fulfilled. And these conditions are, number 1, there should be a law for such kind of interception. Then again, this surveillance should be proportionate to the damage, to the problems that are going to be faced. According to that proportion, state can utilize surveillance. Then there should be a legitimate state interest. It shouldn't be for a personal pecuniary gains. Then finally, there should be a mechanism. Mechanism for what? Because anyway, state is going to overuse its power while intercepting the people, because there's already Supreme Court has upheld this fundamental right of right to privacy under Article 21. Now, this is an overuse of power, overuse of state power. Overuse of power that should be compensated with machinery. If there should be a compensation ground for all this surveillance act, there should be a machinery, mechanism to compensate the public for targeting them. Now, what is the main problem here? The question is that law, is that present? Yes, we have. We have Telegraph Act, Information Technology Act. So different kind of acts are there. But the problem is that who is using the surveillance tools? That is the intelligence agencies. And whether these agencies are established by any kind of law. And this is not done yet. So intelligence agency, now two questions arise. One is whether they should have been kept under the purview of the parliament, because intelligence and defense are two sectors which cannot be compromised at all. So whether they should be kept under the parliament scrutiny, and whether executive action on creating this intelligence agency is justified. State surveillance is a matter of concern not to India only. It is used in United States in the name of PRISM Act. PRISM Act. But this PRISM Act is establishing the American intelligence agencies, different American intelligence agencies, and they have been scrutinized under this parliament, under their parliament, under this act. So, but this kind of act is totally absent in India. Now, hence, there is a need for greater accountability for this investigating agencies. They should be made more responsible, made more accountable. There are lots of reforms has been done in 2011, 2010, 2011. The CBDT, Central Board of Direct Access, are exempted for any kind of surveillance, any kind of surveillance. So hence, there are lots of developments are going on right now. It's a big problem for Indian government and as a nation for today India, because we are missing one of the biggest act, because right to privacy is something that you cannot take any kind of chance. So that's all for today. And finally, before leaving, what can be done? What can be done? Yes, there should be law. There should be state surveillances. But that should be proportionate with the rights enshrined in the fundamental rights in the Constitution of India. So that's all. There's a small class for today, and we'll see you next time. Again, thank you.